Have you been sued by a debt collector and you didn't even know about it? Hi, my name is John Skiba and I'm the founder of the Consumer Warrior YouTube channel. I'm also a licensed attorney in the state of Arizona. And in this video, I'm going to talk about how this even happens. How do you get sued, have a judgment entered against you, and you didn't even know about it? But if this is your first time here to my YouTube channel, go ahead, click subscribe, check that little bell. That way you'll be notified each and every week when I put out a new video that'll help you deal with your serious debt problem. All right, I've been a practicing attorney in the state of Arizona for almost 20 years. I deal with bankruptcy, I deal with debt collection lawsuits, debt collectors, junk debt buyers. I help people deal with all these kind of serious debt issues. And one of the number one things I hear when people are dealing with wage garnishment or debt collection lawsuits is that, how did this even happen? The judgment was entered against me. Apparently this lawsuit went on. I didn't even know it was going on. Now, sometimes I think there are times when people maybe didn't quite understand it or they did neglect it. But I can tell you it's more common than you think that a judgment can actually be entered against you by a court and you didn't even have a chance to defend yourself. Here's how that often happens, is debt collectors, junk debt buyers, original creditors, they will file a lawsuit. These are usually credit cards, medical bills, personal loans. The reason why they want to file a lawsuit is they want to get that judgment, because once they have a judgment, they can then garnish your wages, they can go after the funds in your bank account, they can lien your home, all those kind of horrible things. And so what they do is they file the lawsuit with the court, and then the next step is they're required to serve you with a copy of the summons and complaint. In the state of Arizona, the default rule is they have to hire someone, a private process server or a constable from the court or a sheriff's deputy. They have to bring it to your house and put it in your hand or in the hands of somebody who lives with you. That's what counts for actual service. However, in many of these debt collection cases, what I see is that they say that the collector says they go out and they tried to serve you, they can't catch you at home, maybe you're trying to dodge service, whatever it is, they're saying, hey, we haven't been able to do this, judge. Can you give us an order for what's called alternative service? Alternative service, in most cases right now, is done. The court will allow them to serve you through sending a certified copy of the complaint and the summons in the mail to the last known address, and usually taping a copy of it to the door. And when they do both of those things, the court says that'll constitute effective service, and it starts the clock ticking for you to respond. In Arizona, you have 20 days to respond, 20 straight calendar days to respond to the complaint and summons, or you run the risk of a default judgment being entered against you. And so what I see often is that people don't get served the correct way, the normal way, where they actually receive it. And this is for a number of reasons. Sometimes it's because they don't live there anymore. Usually debt collectors are taking addresses off of credit reports and different types of searches that they've done. Maybe they have a bad address. Maybe you live in a gated community. Maybe you're just never home. Whatever it is, they can't serve you. And so they get this alternative service order. They put a copy of it in the mail and they post it to the door. It's always kind of backwards thinking to me that if they can't catch you at home, usually because they have a bad or an old address, why is mailing a copy of the complaint and summons to that same address going to give you any proper notice? But it typically doesn't. So that's how this often happens. I often see that people don't check their mail very often anymore. And so it may be that they even catch it, but it's too late. So that's how I usually see that these judgments come about, is the lawsuit is filed, it's either not properly served or it's served through the mail and people don't see it. The time goes by to respond and a default judgment is entered. And so often then the first time that people are hearing about it is when they actually get served with a garnishment order or a bank levy, which makes it tough. The good news is, if you've had a default judgment entered against you and you think that they did service incorrectly, that is a basis for getting that whole default judgment process unwound. You can get that taken back to the first step. You do that by filing what's called a motion to vacate the default judgment. And if they didn't do service correctly, it doesn't even matter if it was years ago, you can still go back, unwind that, and give yourself a chance to defend it. So if you're dealing with a default judgment, or if you're dealing with a lawsuit, you're considering bankruptcy, or just ways to deal with it, I offer free consultations. My contact information is in the notes below this video. Go ahead, set up a time, let's talk about it and see how we can help you. Thanks for watching today.